thus requiring expeditious handling so as to avoid the election materials being tampered with. He argued that entertaining this application after 8 days puts their client at prejudice and prayed that the application be dismissed. The Landed Counsel Musa, who appeared for the second and the third respondent, adopted the submissions. And in his further response, relied on the case of Sitenda Sebalu versus Honorable Savin Juba and two others, where their lordships held that jurisdiction of court to entertain a matter is granted by statute, and that once a court's jurisdiction is extinguished by affluctuation of time, like in the instant case, court cannot enlarge time. He observed that the 4 days rule from receipt of the application applies, and the 4 days fell on the 26th of January 2026. He equally invited the court to have this matter dismissed. In reply, Counsel Faizo for the applicant argues that by filing the application on 22nd January 2026, they were within time as per the provisions of Section 74, subsection 1 of the Parliamentary Elections Act. He argued that this court fixed the application to be heard today, 30th January 2026, putting into consideration the weekend and public holiday that fell on the 26th of January 2026. And that he could not serve the respondents with an application which has not been endorsed by court. He invited the court to overrule the objection and have the matter heard. In rejoinder, Counsel Mukama Sanyu Jamil submitted that this court is not closed with jurisdiction to entertain the application today, the 30th of January, the same having been filed on the 22nd of January 2026, which is outside the 4 mandatory days within which this application is to be heard. He relied on the case of Kamba Saleh, where the court held that the Chief Magistrate does not have jurisdiction to entertain an application for a recount filed after 4 days after the receipt of the application, and that where a court purposed to do so, the same is null and void ab initio. Counsel argues that the spirit of the law requires court to suspend all business and hear this kind of applications even on weekends, and that the excuse of weekends and public holidays cannot be entertained. In further rejoinder, Counsel Muasa for the second and the third respondent argued that this was an illegality. It's okay. He wants to close some windows there. Can we proceed? Am I heard? Okay. In further rejoinder, Counsel Muasa for the second and the third respondent argued that this was an illegality, and once an illegality has been brought to the attention of court, the same cannot be overlooked, and he relied on the case of Makula International, to back his argument. He reasoned that this application was filed on the 22nd of January, and the same was not fixed within the 4 days required by law, rendering it improper before court. He also relied on the case of Charles Nsubuga versus Electoral Commission and another, where Justice Stephen Musota, while referring to the authority of Taparo, held that where there is a remedy provided for another statute, a litigant ought to explore all available remedies for appropriate redress. He implored the applicant to seek appropriate remedy under the provisions of Section 79 of the Parliamentary Elections Act, if they are agreed. He reasoned that the applicant, having failed to place himself within the operation of Section 74 of the Parliamentary Elections Act, he cannot exercise his rights under this application, except under Section 79 of the Parliamentary Elections Act before the High Court. He equally shared the view that in election-related matters such as this one, all matters must be resolved within the time fixed by statute, and that court does not have the authority to enlarge time. This is my consideration with respect to that particular point of law. Section 74 of the Parliamentary Elections Act provides for a recount before a chief magistrate. The provision spells out two conditions, and these are: application must be made within 7 days from the date the returning officer declares the results. And this is clearly indicated under Section 74, subsection 1 of the Parliamentary Elections Act. Secondly, on filing the application, the Chief Magistrate is required to appoint time to recount the votes within 4 days after receipt of the application. And this is provided for under Section 74, subsection 2 of the Parliamentary Elections Act. I hasten to add that the process leading to a recount is marred with several other demands, including the filing of pleadings by the parties, the hearing of the application, the ruling of court, and the actual counting itself in the event that the application for a recount is allowed. In the instant case, both the applicant and the respondent appear to agree to the fact that the application was filed on the 22nd of January 2026. The declaration of the first respondent by the third respondent, acting as an agent of the second respondent, was made on the 16th of January 2026. Going by the arithmetic calculation, 22nd of January would be 6 days from the date of declaration. Therefore, placing the applicant within the statutory time limit to file this application as per the provisions of Section 74, subsection 1. The 4 days envisaged for court to dispose of the application and appoint a time for counting would therefore start counting the following day, which is 23rd of January 2026, after the application has been filed, which date is a Friday. Upon court's inquiry, during hearing, it is considered by counsel for the applicant that at the time the application was filed, on the 22nd of January 2026, they had not paid filing fees. Filing fees, according to the receipt attached to the application, was paid on the 23rd of January 2026 at 4:27 p.m. in Iganga, away from the jurisdiction of this court. Counsel for the applicant during court's inquiry claimed that after payment was made in Iganga, a receipt was immediately remitted and was filed with the court at 5:30 p.m. that same date. I do not agree. To my knowledge, there is no single piece of evidence such as a court's general receipt to confirm that receipt so alleged to have been remitted to court was actually filed on 23rd of January 2026 at 5:30 p.m. Furthermore, it is judicial notice that the business of court is usually open between 8 a.m. and 5 p.m. every working day. On that day of Friday, 23rd January 2026, it is to my knowledge as the supervisor of this court that business was closed at 5 p.m. and all officers of court left court after closing all offices. It is therefore not true that the receipt of payment was remitted in court at 5:30 p.m. as claimed. Payment of fees for pleadings filed in court validates pleadings. The applicants having not demonstrated an evidence of payment, court was not obligated to endorse on the application. Given that the 2 days following were weekend, that is Saturday and Sunday, while a Monday was a public holiday, the only date court business resumed, and when court was able to know about the existence of the application or the receipt was a Tuesday, 28th January 2026. The application, was Tuesday, the 27th of January 2026. The application was endorsed the next day, which is 28th, and it was served. No one knows when the receipt of filing fees was finally filed with the court, and this practice itself invoked questionable conduct on the part of the applicant and his counsel, as court cannot ascertain with clarity exactly when the said receipt was smuggled into the court file. That as it may, I agree with the counsel for the applicant that going by the 22nd day of January 2026, this application was brought within the 7 days required by law. However, the same was required to be disposed of within 4 days, which is 26th of January 2026. As the rules, the parliamentary election rules dictate, election petitions are matters of urgent nature, which call for suspension of all court business to give it attention. Where a process has been set into motion by filing the application, business of court should commence and can be conducted on any day including weekends and public holidays. From the conduct of the applicant by filing the application on the 22nd of January 2026 without payment of fees and only bringing to court's attention the fees paid long after a weekend and a public holiday on Monday when courts are closed, the applicant chose to put himself in a disadvantaged position, therefore thereby immersing himself into crossroads with the law. Flowing from the above, I agree with the counsel for the three respondents that this application is outside the statutory period within which it is required to be disposed of. Whether going by 22nd January 2026, when the application was filed, or going by 23rd January 2026, when the purported fees were paid, this application is way beyond the statutory 4 days required for it to be disposed of. These 4 days would expire on 26th of January 2026. Going by the filing of 22nd of January 2026 or 27th of January 2026, if we are to go by the payment of fees of 23rd January 2026. This delay, without a doubt, was occasioned not by court, but by the applicant himself, who did not follow the law to ensure that a competent application is filed in strict compliance with Section 74 of the Parliamentary Elections Act and other laws relating to the hearing of civil matters. I hasten to add that this court has no power to enlarge time within which to hear the application. It was held in the case of Kambasale that where the time provided, whether the time provided for by the law is inadequate or unreasonable, it is not within the powers of the Chief Magistrate to purport to amend the law in his courtroom to enlarge it. The implication is that even if the applicant was caught up by a weekend or by a public holiday as submitted, this court has no power to grant him an extension. Had the court known that fees had been paid in time, the process of hearing the application would probably have commenced, including entertaining it on weekends and the public holiday following. I agree, as rightly submitted by the learned counsel Mwasa, that this application is marred with illegalities, which has come to the attention of court, and proceeding with that, with such an illegality, would constitute an abuse of court process, as echoed by courts in the case of Makula International Limited versus His Eminence, Cardinal Insubuga Wamala, and another, where it was held that an illegality once brought to the attention of court overrides all questions or pleadings, including any submissions, including any admission made thereon. Resultantly, I hold the view that this application is out of time, and therefore extinguishing the jurisdiction of court to entertain it on its merits. Accordingly, I find that the application is incompetent on the second preliminary point of law as well, and the same is therefore dismissed, and it's dismissed with costs to the respondent. It is so ordered.